case number 23-52910CZ for purposes of status conference, as the attorneys have requested on the outstanding petition. May I have the names of our participants, please?
Janelle Shankin on behalf of the plaintiffs.
Andrew Nickelhoff on behalf of defendants.
Very good. All right. I see you have an outstanding summons and complaint. I'd be happy to schedule some dates for you as necessary. It looks like there is an arbitration case pending as well. Is that right?
Yes, Your Honor. Yep.
Go ahead, Mr. Nickelhoff.
Your Honor, I would like to file a dispositive motion. I don't think there are any facts in dispute in this case. And one of the issues, I will be asserting failure to state a claim, and that judgment should be rendered on defendants' defenses. But I also believe that the court does not have jurisdiction in this case. And so, that was not raised it was asserted in our answer, but I did not file a motion because we got this notice. And I wanted to just make sure that it fits with your assessment of the case and whether it's I can file such a motion at this time.
Well, let me.
Yeah.
Sorry, go ahead.
No, go ahead. I'm sorry.
Well, I was just going to inquire of Ms. Shankin if she feels the same way, or if she would be requesting any discovery in anticipation of being ready for a trial on the issue, or an evidentiary hearing, I should say.
We would not need discovery, Your Honor, but we would request mediation from this court. We think this comes down to not an issue of facts, but an issue of negotiation between the parties and their counsel, and we feel that mediation may be the best course forward to reach a resolution.
Have you already had the arbitration, and is it safe to assume unsuccessful?
In the arbitration matter, the UAW filed a dispositive motion to dismiss the claims. The arbitrator granted their motion on one claim and denied their motion on the other claim. So the arbitration is being held in abeyance while we determine the justiciability of the second claim, which was dismissed pursuant to the arbitrator's opinion.
All right. I can give you both. I can give you a date for your motion if you wish to be heard on that, as well as an opportunity for mediation in hopes that you would be able to resolve the issues.
Your Honor,
that works.
Yes, that would be great on the motion. I should tell you, though, that over a number of months, and this is going back well into last year, the parties put a lot of time into attempting to resolve this matter. And we didn't get anywhere, and hence the arbitration and then this action. So I think going back to that chalkboard is not going to really be very productive, because I think we exhausted every possibility of resolving this short of litigation.
Your Honor, if I may respond.
Go ahead.
On behalf of the trustees, we had attempted to negotiate this matter with the UAW, but ultimately we're left with no response on many of our inquiries, which is what forced the co-trustees to file the matter for arbitration and then subsequently come to this court for adjudication of the issue of whether an arbitrator has the ability to modify the trust, as the co-trustees have been requesting of the UAW.
And just to respond, Your Honor, the plaintiffs are seeking to modify the trust agreement, which is called the MIT declaration, because it doesn't give the UAW any latitude, as far as we're concerned, to settle this. This is an ERISA benefit plan, and it's quite clear cut in terms of what can be done and what can't be done. And so we I mean, of course, we'll comply with whatever the court desires here, but we have been through that process already, albeit without a mediator. But I don't think, honestly, that we would get anywhere.
Well, for purposes of your motion, I have some time, January 19th, Friday, January 19th, or you would have to go out to Friday, February 2nd in the afternoon or the morning. Those would be, or then February 16th. So that's what I have available.
Well, I think the second would work for us.
That would be at 10 a.m.
Okay.
Does that work for you, Ms. Shanken?
Yes, Your Honor.
Okay. So why don't we allow, obviously it has to be timely filed and served, but we'll reserve to you Friday, February 2nd at 10 a.m. Is an hour long enough, you think, or you want more time than that?
I think that should be long enough.
Okay. All right. Well, Ms. Shanken, on the issue of mediation, how would you propose that the fees and costs be shared?
We would propose a 50-50 split between plaintiffs and defendants.
And who would you propose mediate?
This could be up for discussion. I'm sure counsel for the UAW and I could come to an agreement on a suitable mediator. Admittedly, we have not looked into specific mediators as of this time.
Right, Mr. Nikoloff, would you be willing to engage for approximately 2 to 3 hours for a singular mediation? Or at least an attempt to that? I mean, obviously you don't have to sit there for 3 hours, but I would ask you to perhaps come to the table for a reasonable amount of time under the circumstances, in your opinion, to see if there is any preliminary issues that you could navigate. And then obviously that would narrow it for whatever you would need to file in your motion.
Your Honor, of course, we'll be happy to abide by whatever the court indicates. But as I said, we have been through that process without a mediator, and honestly, the UAW does not have a lot of wiggle room here. In fact, it has none, as far as we're concerned. We're legally obligated to enforce the trust agreement as written.
If I may respond, Your Honor.
Go ahead.
The entire argument for the co-trustees is based on language in the trust agreement that gives the UAW ability to agree to a modification of terms or to a disbursement that should not be unreasonably withheld. And that's the language that the co-trustees believe allows the UAW to make such an agreement with the trustees and working together to resolve this dispute.
Anything further on that, Mr. Nikoloff?
No, I don't think we can reasonably accede to a premature distribution. And what I would emphasize, and what I will in the motion, is that this is an ERISA welfare benefit plan. And so that puts it in a different category. In fact, it's a trust that is outside of the probate court's jurisdiction under EPIC. And so we're, as far as we're concerned, we're in the wrong ball field here. And beyond that, we were willing to discuss it with the other side, with the plaintiffs, but we really can't. I don't think that not only is there not common ground? But I'm concerned that my client would be exposed to potential liability by agreeing to anything other than what's in the trust agreement.
Very well. Well, we can confirm that you'll have your date on the 2nd of February at 10 a.m. for purposes of the motion as requested. And I think asking the parties to come together for one attempt at mediation between now and then could potentially be useful. If nothing else, to delineate specifically any issues or questions that would need to be answered prior to the motion date and time. And if it's not resolved by that, I'll expect just simply a report that everyone appeared and engaged in that effort. And then I'll look forward to seeing you on February 2nd at 10 a.m. for purposes of pretrial and potentially the motion. At this time, given that there does not appear to be a factual dispute by either side, and it's all legal issues, I would not be inclined necessarily to give you a trial date at this point, unless you would like.
Oh, we see no need.
Agreed.
All right. Well, thank you both for coming and for your patience. We'll see you back in February. You should share the cost of that, a singular attempt at mediation. And if you can't choose a mediator, you know where to find me to settle that dispute.
Thank you, Your Honor.
Thank you, Your Honor. One question for logistics. On February 2nd, will that be an in-person hearing?
Well, I do know that there are times where you would have potentially witnesses for such a motion. Are you anticipating that, Mr. Nikoloff?
Not at all. No, we're going to file a dispositive motion for summary disposition. And so if there are no witnesses, my preference is just to do it the way we're doing it here.
We both seem to have a decent Zoom connection that we're picking up just fine in the courtroom. So if you'd like to appear by Zoom for purposes of that pretrial and motion, unless something changes and your internet goes sour, then you can expect me to require you to be here. But other than that, I have no problem with you appearing by Zoom in February.
Thank you, Your Honor.
Thank you.
All right. Ms. Shanken, would you be so kind as to prepare the order as indicated?
Yes, Your Honor.
Very good. I'll look forward to signing that. Unless there's any other questions, that would be all for today.